connecting people, building communities, helping clients to build multi-generational wealth through real estate.
Today, we have the privilege of having Bobby Vakili with us again. Bobby is the founder of Vakili Law Group, a boutique law firm located in Thornhill, serving the greater Toronto area. They are focused on real estate law, private mortgages, business law, and wills and estates. So what we experience, Bobby, unfortunately, tenants somehow become very smart on doing certain things to delay the process of eviction. For example, they don't pay the rent all at once. They pay part of it at, let's say, on the 15th of every month, and then the remainder within 14 days. We have a situation where the tenant is ill, lost a job, and has been making late payments since last year, and she's also not moving from the unit. And on the other side, we have a landlord client who is having financial struggles because of the current mortgage rent increase. Rate has increased tremendously, and they cannot even cover the expenses. So how long can a tenant pay the rent late and just play that game, which has a huge negative impact on landlords?
Yeah, I mean, as soon as a tenant misses a rent payment, you can file the notice immediately. You have to give the tenant 14 days to cure the default. If they don't cure the default during that 14-day period, then you can make an application to the landlord and tenant board to evict that tenant for failing to pay rent. Now, as I've said before, as a result of COVID, there's a huge backlog, and it can take up to a year to get a court hearing date. So during that time period, unfortunately, you can't really, as a landlord, you can't do much more than just wait for your court hearing.
So you see, we have, let's say, a landlord who is very compassionate about the whole situation. They definitely want to cooperate. And the intention is literally making sure that they would have rent payments that would cover at least most part of their mortgage payment. And if there is a 8 months delay, and they started to realize that if they do not send the notice, the N4, they are not going to go anywhere with that matter. How many forms they need to send just to create a level of pressure or urgency that then they send the eviction? Because in reality, some landlords simply, they want peace. They don't really want to create problem for anybody. And they really want to make sure simply that the payments are paid. So after how many notices, they can file the eviction. And then if, let's say, they have all the records showing that there has been late payments, and then let's say they applied for the eviction 6 months later, would that take another 8 months to a year till the eviction takes place? So what's the situation?
Well, to answer the first part of your question, they can apply to evict the tenant, like I said, immediately. Once they miss payment, you have to provide that notice and then 14 days to cure. If they don't cure within that 14 days, then you can apply to evict the tenant. Now, because it takes so long to get to a tribunal hearing, and there may be an accumulation of further missed rent payments, you don't need to provide a notice each time. We're not like a formal N4 notice. It's still a good idea to send a notice to the tenant in writing, whether that's by email, text message, or sending a letter by regular mail. That's a good idea to do every time they miss a rent payment. And then when you actually attend the hearing, you're going to provide the tribunal an updated sort of loss of rent that you've suffered over the last several months. And based on that, the tribunal will make an order for all the rent arrears plus eviction if deemed appropriate.
So, if, for example, the landlord sends the notices via email, would that be sufficient, or every time it needs to be couriered, delivered in person?
Yeah, that's a interesting question, and I have a funny story about this. The lease typically now dictates how notices are to be provided. So
Yeah.
the lease agreement was standardized in, I believe, 2018, and so there's notice provisions within the lease, and that's how you would typically provide notice. Prior to that, the lease agreement wasn't really standardized, and I had a case many years ago where every time we wanted to, I was representing the landlord wanted to sell the unit. It was a condominium, and the landlord, every time he had a showing, he would provide notice to the tenant via text message or email. And then after a certain period of time, the tenant was uncooperative from the beginning. But after a few notices were provided, he was starting making complaints that, this notice was not valid because I went on a digital detox. And so the tenant started making complaints that I no longer agree to accept any communication by email or text message. But ironically, whenever he wanted to make a complaint to the landlord, he was using email or text message to communicate with him. So it was all one-sided. The landlord couldn't communicate with the tenant via email or text message, but he was permitted to do that. And ultimately, the tenant made a complaint to the Municipal Affairs of Housing, and they were investigating the landlord for unlawful entry into the unit because of that notice was not deemed sufficient. And because of that, they were investigating, and they were planning to charge the landlord with an actual offense, which in my mind was ridiculous. But that was the what was going on, and ultimately the landlord had to just pay the tenant a significant amount of cash for him to vacate the premises, essentially cash for keys.
Wow. So, if, for example, the tenant responds to the email confirming the receipt, would that be sufficient, or do we still need to deliver courier the notice?
No, like I said, it's what the agreement says. So now the agreement typically says
Yes,
notices can be received by email.
that's right.
And if you send a notice by email and you have a confirmation that it was delivered, that should be sufficient.
Okay, beautiful. So if landlords decide to sell the property or do a major renovation or simply take over the property using it here and there, weekends perhaps, would that be something that would be permissible to terminate the agreement?
So you raise a lot of issues there. So if they're selling the property, yes, you can terminate the lease so long as it's a monthly tenancy, not if it's in a fixed term.
Mm-hmm.
And in order to terminate a lease, because you're selling the property, you can't do it before you actually sell the property. You have to wait until you actually sell the property, and then the buyer needs to declare that they plan to move into the property and use it as their primary place of residence. Either the purchaser or an immediate family member of the purchaser would have to make that declaration. Otherwise, the purchaser is deemed to assume the tenant. So, and in that situation, when a purchaser is in fact planning to move in, the seller or the landlord would have to pay 1 month's rent compensation to the tenant as well. So
Yeah.
that's that situation. The other situation for renovations, you can, terminate a lease again as long as it's a monthly tenancy and not within a fixed term. The landlord could terminate a lease in that scenario as well. But again, you would have to, you're obligated as a landlord to allow the tenant to move back in after the renovations are completed at the same rental rate.
Allow the tenant to move back at this rent that, let's say, was applicable 6 months before?
Correct. Whatever the rent was prior to the renovations, the landlord has an obligation to allow the tenant to move back, and the rent has to remain the same.
What if the tenant, the landlord actually wants to renovate and move in themselves to just use the property anytime that they want? Is that still permissible to terminate the agreement?
Yes, in that instance, so long as it's a monthly tenancy, they could terminate it. That's, again, personal use sort of exception. But they would need to pay the tenant 1 month rent in order to do that. And, the owner would need to move in for a minimum period of 1 year, and it would have to be their principal place of residence. So if they only plan to use it as like their place on weekends, I don't think that would pass, and the tenant would probably successfully challenge that.
So if, let's say, landlord's siblings or children want to move, would that be still okay to terminate the agreement?
Correct. The landlord's children, spouse, parents, yeah, all of those immediate family members would be permitted.
Okay. What if, we have a situation, that's why I'm asking those questions. What if, let's say, the landlord wants to do all that simply because the tenant is not making the payments on time, creating problems, and then they just simply think that they'd rather either sell the property or renovate to move in, or let the children or parents move in? So in a situation like this, can they send the notice N4 and N12 at the same time? Or what form would supersede the other? What should they do?
Yeah, you can submit both of those forms, together. There's no rule that prevents you from doing that. And the N4 would obviously be for rent arrears, and the other form would be for the N12 is, for personal use. Keep in mind, with the N4, obviously there's no requirement to pay the tenant 1 month compensation, but with the N12, you are required to provide 1 month rent compensation. So it may not be the best idea to submit both, but you can certainly do it.
So what would you suggest in a situation like that?
If there's a history of the tenant paying rent repeatedly late, then, I would just pursue and proceed with the N4 application. I don't think there's a real need to provide an N12 application.
Okay. And anyway, landlord does not need to explain anything to the tenant except that, simply they want the rent to be paid. And what if, let's say, after 8 months or 12 months, they go to hearing, and then the tenant is going to pay the full rent upfront, the late payments, all at the same time as a lump sum, but the landlord wants to still let go of this current tenant? What needs to happen at that time?
Right. Yeah, that's a good question, and that comes up as well. So if the tenant does pay all the rent arrears prior to the hearing, the landlord will no longer really have a basis to evict the tenant at that point, unless they've done this, repeatedly several times. So if maybe this is the landlord's second application to the tribunal for late payment, and then the landlord and the tenant again, right before the hearing, pays all the rent arrears to avoid eviction, in that instance, the tribunal is going to be sort of more on alert as to this seems to be gamesmanship on the part of the tenant for not following the terms of the lease, and they'll be more inclined to order an eviction in that instance. But if it's the first time that this is occurring and the tenant pays all the rent prior to the hearing, I suspect on a first instance, the tribunal is not going to order an eviction.
Mhm. So the situation is that if, let's say, the landlord is very vulnerable financially, the tenant is very vulnerable also financially, they are not just simply not a good match. Definitely, no one has the intention to hurt the other, but they actually hurt each other. And do you think in a situation like that, the landlord rather gives the notice N4 and N12 just in case they go to hearing? Because, that's the fear of this is going to happen again. Okay, they are in a hearing. That's why the tenant is paying the rent that was delayed by 8 months or a year. And then what if it happens again? And landlords can be in a very vulnerable position. What would you recommend in a situation like that to avoid future delay in rent payment?
Yeah, if in that instance, if the tenant is, sort of has financial hardship, I don't think the tenant would be in a position to pay all the rent arrears all of a sudden before the hearing. So, you would have to make that assessment and decide whether you want to proceed with the N12 application as well. Just keep in mind, if they proceed with the N12 application, they do need to pay 1 month's of rent. So it really depends on the factors and the party's intention, and the financial, sort of circumstances of the individuals. But in that situation, it may be beneficial to proceed with both applications.
Okay, great. So, Bobby, with your experience, if let's say landlord and tenant goes to hearing, both parties are very vulnerable for different reasons, different financial health issues. In your opinion, the tribunal is going to take side of the tenant or the landlord? It's a common sense. The tenant cannot pay the rent for their reason. Landlord cannot cover their mortgage payments because of the late payments. Would they still take side of the tenant or the landlord?
Again, we would have to review all the facts in any particular case. But, the law is clear. Like, you have to pay your rent. So if you don't pay your rent, there's a basis to evict the tenant. At the same time, though, and especially ever since COVID, the government and the tribunal has put more and more pressure on landlords to find a way to work with the tenant. And so there is this unwritten expectation that, the landlords are expected to work with the tenant to find a solution in good faith. So that's also a factor. Like, if the tenant is offered to pay the landlord, on a certain payment plan that isn't going to create any real prejudice to anybody, in that situation, the court may say, well, to the landlord, they've proposed what seems to be a reasonable repayment plan of rent arrears. Why didn't you accept? So it really depends on the circumstances, what efforts that both sides have made to find a solution. But I'm seeing more and more often that the landlord is expected to sort of try to find a solution with the tenant.
Connecting people, building communities, helping clients to build multi-generational wealth through real estate.